Ladies and gentlemen, as you've heard, today's event will feature two mock arbitration hearings. They're quite separate matters. The first hearing concerns a jurisdictional challenge. In other words, does the tribunal have the power to hear and decide this dispute? As members of the audience, you should have received via email two statements of facts. If not, you'll have paper copies here. The one to look at now is the statement of facts pertaining to jurisdictional challenge. From the title at the top, you'll see that the arbitration is taking place under the HKMAG terms 2021. And as you know, HKMAG terms closely follow LMAA terms. So it's a set of rules with which you're familiar. As regards the facts, the claimants are insurance company C. The respondent company B is the owner of the vessel. And from the statement of facts, you'll note that there was a voyage charter between the owner B and the charterers who were called Company A. So what went wrong? During discharge, cargo belonging to Company A was dropped onto another parcel of cargo owned by Company D. The cargo insurance company C paid out and became subrogated to the cargo claims, so I understand. And that insurance company then commenced this arbitration under the arbitration clause in the charter party. Now, if that sounded a bit complicated for a Friday afternoon, don't worry. It's a jurisdictional challenge, so the facts can't be too straightforward, and you'll soon hear more about it. For this first hearing, we're privileged to be joined by prominent arbitrators and very talented practitioners. The tribunal is chaired by Mr. Damien Laracy of Hill Dickinson. His co-arbitrators are Miss Julia Ju of the Swedish Club and Mr. Jagmeet Makar, an independent arbitrator. The applicants here on this side are represented by Mr. David Fong of Harcourt Chambers and Miss Julia Ju of Skuld. And before this session, the two Julias kindly explained to me how to pronounce their surnames. And you will all have picked up on that subtle difference of pronunciation that I succeeded on just then. I won't attempt to do it a second time. The respondents are represented by Mr. William Leung of William K.W. Leung & Co. and also Mr. Nathan Hsu of Stevenson Harwood. So with that, can I turn it over to the tribunal and parties?
Yes. Good morning, Council. Can everybody hear me clearly? First of all, some housekeeping matters from the tribunal. Unless anybody says otherwise, I will assume that it is accepted that this tribunal this afternoon does have jurisdiction to deal with this dispute as to our jurisdiction. Is that correct?
Yes, Mr. Chairman.
Thank you. So that is noted for the record. Are there any other housekeeping matters that either party would like to raise before we move on?
Chairman of the tribunal, I am representing the respondent, the respondent ship owner. As to the statement of facts, we have got a couple of housekeeping matters I would like to draw your attention. Paragraph 1, line 2, the sentence chartered the MV-XYZ, that is the name of the ship, instead of to the despondent owners, it should be from the despondent owners. Yes, and there are some minor typo mistake here, which I would like to clarify. In paragraph 2, third line, the owner and the instead of character, it should be charter. So any other character here, I mean, it should be charterer. So that's yeah, all housekeeping matters I've got that in mind.
Thanks for that clarification. Right now, before we go any further, and again for the record, we are sitting this afternoon in relation to a Hong Kong arbitration, a Hong Kong seated arbitration, and we are the governing procedural rules are those of the Hong Kong Maritime Arbitration Group, HKMAG. Mr. Leung, you do have a challenge to the jurisdiction of this tribunal. So I believe it's now your opportunity to make some submissions. We have read the papers.
Yes.
But obviously I'll leave you to supplement the submissions as you see appropriate.
Yes. All the tribunal members, I've already submitted my skeleton submission on the jurisdictional challenge, and I'm going to repeat them. Now, my colleague Nathan Shu, he is dealing with the merit matter, and I'm dealing with the jurisdiction matter. And we represent the ship owner respondent to challenge the jurisdiction of this tribunal. I just want to make sure that everybody clear. Yes. To rule on the substantive dispute between the insurer claimant and the ship owner respondent. And the summary of facts, I very briefly take the tribunal to the summary of facts here. The charterer company A and the ship owner respondent entered into this voyage charter party. And the cargo used for carrying the hot rolled coil was covered by the insurer's policy, underwritten by the insurer claimant. An accident occurred, and the cargo of the charterer A and the cargo of the storage tank owner D was damaged, causing loss to both the charterer company A and the storage tanker owner D. And the insurer claimant paid the compensation to both the company A and company D, and they executed subrogation forms to the insurer claimant. However, no notification was sent by any party to the ship owner B. That is the respondent here. The insurer claimant then commenced this arbitration pursuant to the dispute resolution clause of the charter party. And the ship owner respondent dispute the jurisdiction of this tribunal.
Did I just ask you a question at that point? Have you raised this challenge to jurisdiction before the time when any defence was due to be filed?
Yes, we do.
Thank you. So I'm just, for the record, you're confirming to me that the challenge to jurisdiction has been lodged before the time required for lodging any defence.
Yes, yes. We are indeed lodging this objection to the jurisdiction at the first instance. And the tribunal members, if I may take you to the dispute resolution clause itself, and it is in the agreed facts in paragraph 2, and I'm not going to I'll read only the material part of it. Any dispute arising or in connection of this charter party this document charter party, right, can be resolved by negotiation between the ship owner respondent, and the charterer. On the plain literal construction of this clause, the party to the charter party can only be the ship owner respondent and the charterer, and only they can enforce this clause and nobody else. Now the owner is the the ship owner respondent and it can be presumed that when this charter party was entered upon, both never intended, both the ship owner respondent and the charterer never intended any parties to be incorporated into this clause. Additionally, if you read this clause further on, the second sentence, if the dispute cannot be resolved within 60 days from the commencement of negotiation, any party can submit the dispute for arbitration under the HKMAG terms. Now, this any party here is important because it only meant the effect of it was to exclude any other party, including the insurer claimant, to enforce the arbitration clause. If the clause was intended to include the insurer claimant, the clause should have read any party or is subrogated assignee or authorized body can submit the dispute for arbitration. The words or subrogated assignee or authorized body never appear there. It's not there. So any party can only means the parties of the charter party. That is the respondent owner, ship owner, and the charterer company A. Under the this is the point I want to make, and the point is fully supported by legal authorities. Mr. Chairman. In my skeleton, I've referred to the book by Joseph, in which he said the construction of the dispute resolution clause shall align with the parties' mutual intention using ordinary principle of construction. Suffice to say, on the proper construction of the clause, any party other than the respondent ship owner and the charterer company A, other than these two companies, any other companies, including the claimant insurer, are to be excluded from enforcing the dispute resolution clause. This is the first part of my submission. The second part of my submission is concerning about the damage of the road plate, the suffered parties being the storage tank owner, the road plate. The hot rolled coil, we submit that failed to fall within this clause because it is simply not within the scope of, as prescribed under this dispute resolution clause. The scope as prescribed here is any dispute. If you read the first sentence of the arbitration clause here, any disputes arising or in connection of this charter party. Now the damage we submit that has got nothing to do whatsoever with this charter party at all. It is a consequential damage as a result of the crane of the vessel or of the ship owner when during the crane has accidentally damaged this hot rolled plate, which has been stored at a storage tanker at a storage tank. It is not within the scope or even within the contemplation of the scope of the charter party at all, because the charter party is a contract of transportation.
Mr. Lowe, can I just
Yes.
ask you a question on that one? You've referred to the charter party a number of times, and you referred to the dispute resolution clause in the charter party. You've not yet referred to any bill of lading. Were there bills of lading, and what's the relationship between any bill of lading and the charter party dispute resolution clause that you're relying on?
Now, the bill of lading was issued by the ship owner. The charterer. The bill of lading was issued by the charterer, as far as we understand, because it is voyage charter party. We say, despite the issue of the bill of lading, despite the issue of lading, we say that it has not been incorporated into this voyage charter party. There's no incorporation clause as such, and so we submit that the clauses in the bill of lading is irrelevant in the determination of the effect of the charter party, in particular to the effect of this dispute resolution clause. Now, if I may further make my submission as to the, let me go to the law itself. Our objective interpretation of the clause is supported by way of, I have referred to in paragraph 7.2 of my opening, contract rights of third parties ordinance, chapter 623, and in particular section 12, which states that a third party is not entitled to enforce a term of a contract subject to the arbitration agreement if, open quotation, on a proper construction of the contract, the third party is not intended to be so treated, close quotation. And we submit that this third party is, and the claimant insurer here in this arbitration proceeding is exactly the third party the section is referring to. It can be objectively viewed from both statutory perspective, literal construction, that the claimant must have been precluded from the application of the dispute resolution clause in the charter party. And on evidence, the insurer claimant has never been a party when signed, not even considered by the parties. And the wording of the latter part of the clause, reading between the owner and the charterer, must imply exhaustion and exclusion of any other party to the clause. The insurer claimant never signed or by any means to be included or involved in the clause. And my learned friend has referred in his opening submission, referred to a case.
Counsel, I just would like to ask you, you're saying the underwriter has not been included in the clause. Do I understand it correctly? The insurer is not included in the clause.
Yes, yes.
So normally, as we understand, the insurance is for unforeseen circumstances, not for foreseeable circumstances. So do you think still, having understood this principle of insurance, the underwriter should be part of the dispute resolution clause?
We say it should not be because of how this particular dispute resolution clause has been so worded and and has been so phrased. We say as a matter of construction, they should be excluded. Well, of course, I'm not saying in a general sense. I'm saying in this particular case, our submission is that this is a very specific case and so fact specific And my learned friend has referred you to in page paragraph 11 of his opening submission. He referred to a case called RALS, RALS. And then he made a few submissions which I'm not going to repeat. But suffice to say, my learned friend has failed to refer the tribunal. He referred the tribunal only to paragraph 52 and 53 of the judgment. And instead, my learned friend has failed to refer you to paragraph 55 of the judgment. And in fact, in paragraph 55, if I may read it out. In the middle of the paragraph 55, beginning with regarding the second proposition, there is less difficulty. And right in the middle, it is a Court of Appeal, Singapore Court of Appeal case. Singapore Court of Appeal case, and in fact, the judgment was delivered by a very famous Court of Appeal judge in Singapore, Judith Flakash, J.A. She said in the middle of the paragraph, this approach of entitlement rather than obligation may be more easily reconcilable with the consensual nature of arbitration. This is because the assignee is only taken to submit to arbitration at the point he elect to exercise his assigned right. If he chooses to do so, we see little reason why the consent of the assignee cannot be inferred from that choice. This, however, potentially gives rise to another conceptual difficulty. That is, allowing non-parties to an arbitration agreement to avail themselves of the right to arbitration under the agreement would on the face conflict with the doctrine of privity. But I'm sure the tribunal members are all too familiar with the doctrine of privity of contract. Now, further on, I would make my bring the tribunal to a little bit more insight in apart from my opening. Is in paragraph 9 of my opening. I refer the tribunal to a case called the Lingman case. The Lingman case. And in paragraph, I draw to the tribunal's attention to paragraph 30 and 31 of the judgment.
Mr. Leung, could I just remind you, we have limited time
Yes.
this afternoon, and I trust you to
Of course, I'm going to finish quite soon.
manage your time with your co-counsel.
Yeah. Now, the paragraph 31, I would draw your special attention is to the second paragraph. But where the assignment is the assignment of the course of action, it will, in the absence of some agreement to the contrary, include as stated all the remedies in respect of that course of action. So we stress absence of some agreement to the contrary. We say in this particular instance, both parties, the owner, ship owner, respondent, and the charterer company, by way of entering into this particular dispute resolution clause, they have chosen to the contrary. And as far as in paragraph 10 of my opening, I've drawn your attention to a case which in fact has been done by my own firm. It's called the Dixon Volara Group Holdings Company against Fan. It is an anti-suit injunction, and the judgment was delivered by Godfrey Lam in the year 2019. And his lordship has drawn attention to. I would like to compare and contrast the arbitration clause in that particular case to here. In that arbitration clause in that case is any dispute, controversy, or claim arising out of or relating to this agreement or the breach, termination, or invalidity shall be settled by arbitration. Now here, the stark contrast is that the word party, the stark contrast is here we have got of this charter party between the owner and the charterer. All these are missing in that case. So I will submit that we are, in this particular instance, the Dixon case should be distinguished. And Mr. Arbitrator, I would like to wrap up my my submission here. Bearing in mind the time, and then if there is anything you would like to raise with me, otherwise I will pass it on to my colleague.
Thank you, Mr. Loom, and look forward to hearing from your co-counsel.
Thank you so much.
Thank you, Mr. Learn. Members of the tribunal, if this tribunal disagrees with the respondent's position on assignment, then for the following reasons, we say that the arbitration has not been validly commenced, and therefore this reference must be dismissed anyway. There are two undisputed facts which we can see from the statement of facts. The first is that this dispute resolution clause is multi-tiered. The parties can first resolve the dispute by negotiation. After 60 days, if after 60 days it cannot be resolved, then either party can submit the dispute to arbitration. And this is in paragraph 2 of the statement of facts. In other words, negotiation first, arbitration second. Second, there has been no attempt whatsoever to negotiate a settlement before the claimant purportedly tried to commence arbitration. And this again is clear from paragraph 5 of the statement of facts. Our position is quite simple. Because there was no negotiation or no attempt to negotiate a resolution of these disputes, there can be no valid commencement of arbitration. The claimant's position is also simple. They argue that because of the word can, it means that it's entirely optional to negotiate or jump straight into arbitration. And we say that this cannot possibly be correct. The claimant's interpretation requires the tribunal to ignore the first half of the clause and read only the second half. And that cannot possibly be correct. We say this because the word if divides the requirement to submit to negotiation and the requirement to submit to arbitration. It says, if the dispute cannot be resolved within 60 days from the commencement of negotiation, any party can submit the dispute for arbitration. The word if represents a condition precedent. It does not say, as the claimant might suggest, regardless of whether negotiation happens or not, that would render the 60-day requirement completely meaningless. And if negotiation was purely optional, then what is to stop the claimant from offering to negotiate and then 5 days later, 10 days later, decide to just commence arbitration? The words are there for a reason. And it is our view that 60 days has to pass after negotiation has been commenced before arbitration can be commenced. Once the tribunal accepts that arbitration must follow on from negotiation, then the next question is to consider what happens when arbitration is incorrectly commenced. From all the authorities and the textbooks that the tribunal has before it, the prevailing approach we accept is that the tribunal and the court will all favor arbitration over litigation. Where there is a choice between sometimes arbitration, sometimes litigation, versus always arbitration, there's a predominant favoritism towards always arbitration. There is no mix and match between the two approaches. But we say, in this case, it should be the other way around, because that is the only reasonable interpretation of the party's intention. And preserving the voluntary nature of arbitration is critical. The respondent's position is that any party can initiate negotiations, and after 60 days, that party may commence arbitration. But if negotiations are not initiated, then no arbitration is possible because we cannot read after the word if. And the remaining course of action must be litigation. And this interpretation aligns with the plain wording of the dispute resolution clause and is the only sensible inference of the party's intent. And if the tribunal wishes to have authority in support of that, we have the 2004 Hong Kong case of Thorn Security Hong Kong Limited versus Turnkey Fung Churn Construction Co. Limited, where it was held that an option to arbitrate within certain time limits does not automatically mean that an arbitration agreement has been formed. Now, even if, and this is our alternative case, the tribunal disagrees with us on this point, then we refer the tribunal to the Singapore Court of Appeal case in International Research Corp PLC versus Lufthansa Systems Asia Pacific Pte Limited. In that case, the court held that where parties have contractually prescribed dispute resolution procedures as preconditions for arbitration, then unless there is a waiver of any kind, then compliance is required for invoking the agreement to arbitrate. And I think I can just leave the tribunal with a reference to the case in case they want to refer to it later. And that is paragraph 63 of the Lufthansa case. I'm aware of the time, and whilst I was intending to go into the CND case because it's a very seminal recent Hong Kong Court of Final Appeal case, I think I will leave that for reply if necessary. I think in short, I think the claimant and the respondent are in agreement on what the CND case means. It means that the tribunal can have jurisdiction today, but whether it has jurisdiction over the rest of the dispute, the substantive disputes, depends on whether preconditions have been satisfied, and we say it hasn't. And therefore, in summary, we respectfully seek a declaration from the tribunal that it lacks jurisdiction to hear the disputes under the charter party due to the claimant's failure to comply with the mandatory preconditions. Thank you.
Thank you, Mr. Hsu. Just before we turn the microphone over to the claimant's team, I'll ask my tribunal members if they have any questions.
Just a very quick one, Counsel. First of all, thank you very much. You're saying, in your opinion, there's a condition precedent to have the negotiation. So if, for example, that word can was replaced by shall, how does that condition precedent differ, in your opinion?
Thank you, Mr. Arbitrator. I think if the word can is replaced by shall, then we get very close to the dispute resolution clause that we see in other cases, such as CND, and perhaps the tribunal's hand is more tied, and we have to find a way around. There is certainly an arbitration agreement which can be enforced, and therefore the claimant party will have to satisfy that precondition and then commence arbitration. We say that this case can be distinguished because the claimant party can commence litigation instead as an alternative. If there is no negotiation, if they do not wish to pursue that route, they can just go straight to litigation. Thank you.
Thank you. Mr. Fong, I'll now give you the opportunity to respond to those submissions on behalf of the claimant.
Yes. Yes, may it please the tribunal, Mr. Chairman. I appear today with my co-counsel, Ms. Ju, and insofar with the list of issues before the tribunal is concerned, I will address the tribunal on issue 1, the assignment, while my co-counsel, Ms. Ju, will particularly address the issues 2B to the tribunal. Mr. Chairman and member of the tribunal, after hearing the submission of my learned friend, I am almost so convinced that I am totally wrong and I should withdraw the case. However, up on a second review of the case, I find that actually my learned friend is so wrong that I must address the tribunal properly about the proper law. Now, members of the tribunal, can I trouble you to turn to the Cayman's skeleton submission? Paragraph 5. Now, the issue before the tribunal, as the list of issues properly read out, is about talking about the assignment itself. The first item is that whether the subrogation form effect a legal assignment or equitable assignment. Last, let's go back to the basic. Mr. Chairman and the member of the tribunal, if you look into paragraph 5 of the Cayman skeleton, I have publicly cited the authority. In the insurance context, it's common for insurer to take an assignment of the assured's claim against the third party. If the insurers take a legal assignment, the action against the third party is then to be brought in the insurer's own name. This may be done by express letter of surrogation or by a policy term. Now, in this case, as tribunal would look from my skeleton argument, the position of the Cayman is that the present form, the surrogation form, took as a legal, not as a legal assignment, but rather as an equitable assignment. This is by the operation of law, and it goes beyond the interpretation of the contract. Mr. Chairman and member of the tribunal, I know you are so well familiar with the basic law of the Hong Kong SAR. And in the chapter 1 of the basic law of the Hong Kong SAR, it specifically say that the law of equity is being preserved in Hong Kong. Thus, we rely on that. Actually, this is an equitable assignment itself. Now, the reason for the equitable assignment, I had already stated in paragraph 7 to paragraph 10 of my submission, and I do not intend to repeat it in details. However, basically, is that for legal assignment, the condition is under section 9 of the Law Amendment and Reform Consultation Audience must be complied with. However, in the present case, as the tribunal would look from the statement of facts, there is no notice sent out by the insurer. Therefore, the strict condition of the legal assignment under section 9 has been not complied with. Then it falls into being an equitable assignment, which is a adoption developed by the Court of Equity at the time in England and Wales and being preserved by the basic law. As you can see from paragraph 10, subparagraph 2 mentioned the treaty of contract, a legal authority, and assignment which fails to comply with the statutory requirement will take effect as perfectly good equitable assignment. Like in this case, it's clearly is a equitable assignment. So thus the contract right of third parties orders do not have any play into the present case as being cited by my learned friend. Now, on the other hand, Mr. Chairman and member of the tribunal, I invite you to turn to paragraph 10 of the respondent's skeleton. It mentioned one particular thing. As such, if company and company especially agree that the arbitration cost is not assignable. Now, however, in the present case, there is no long assignment cost contained in the charter party. Therefore, by the operation of the equity, definitely the arbitration cost can be assigned. Now, I have already cited the authority about the assignability of an arbitration cost, and I do not intend to repeat here. Now, then it comes to the third point that whether the charter party and the company are required to be joined as claimant of the arbitration. Now, Mr. Arbitrator, Mr. Chairman and member of the tribunal, I invite you to turn to paragraph 12 of my scattered submission. It refers to the case of TNA. It refers, may I trouble you to look into the paragraph 55, subparagraph 2. I cite in that particular paragraph, and I've been highlighting both forms. There is, however, a long-standing practice of the court that before giving final judgment in an action at the suit of an equitable assignee, the court would normally require him to bring the assignor before the court, either as the plaintiff or as a defendant, in order that the assigner would be bound by the result. Then on the list subparagraph, the practice of requiring the assigner to be made a party to the action is a procedural and not substantive requirement. Now, on this authority, quite popularly, the insurer need to bring the assigner to this case, but only require before the tribunal render the final award. So at this stage, there's no debar for the insurer to commence the present arbitration before this tribunal. Now, I would like to supplement one further point about the assignment. Looking back into paragraph 54 in the same paragraph, is referred back to the case TNA. Although no notice of assignment was given to prior to the commencement of the arbitration, for the reason mentioned in paragraph 45 above, I shall proceed on the basis that the surrogation form take effect as an equitable of assignment of T's right of action against B2A. Member of the tribunal, can I trouble you to look into the same authority and Cayman's list authority number 6? On paragraph 45, referred by the learned judge, Mr. Justice Anderson Charles, in this paragraph 45. And maybe I can assist the tribunal to read out the passage I like to rely on, not to trouble the tribunal to turn to the page. Paragraph 45 read at the beginning. This is not in dispute that no notice of assignment of T's right and remedy under surrogation form was given to be prior to the commencement of the arbitration. And then the judge at the end said, I shall come back to the question of the legal effect of the surrogation form under English or Hong Kong law when I consider issue 5 later in the judgment. Now, issue 5 is being covered under paragraph 54 and 55. So on this authority, it falls squarely into our case that exactly is like the case TNA is an equitable assignment, and thus the insurer has every way to commence the arbitration against the respondent under the surrogation form. This is the first part of my submission. Mr. Chairman and member of the tribunal, is there any questions I can assist the tribunal?
I have a question.
Yes.
You have framed your position on the basis that because there was no notice given to the debtor,
Yes.
the disponent owner of the business,
Yes.
you framed your case on the basis that because there was no notice given, you're dealing with an equitable assignment.
Correct, Mr. Chairman.
But Section 9 does not require a notice to be given at any particular time, does it? Could it be the case that at the time you commenced this arbitration, that was sufficient notice under Section 9? In which case, could it be the case that you have in fact taken a legal assignment?
Well, thank you, Mr. Chairman, for your question. You rightly point out it rather depends on ultimately whether any notice has been given. Up to this point, there's no notice given, so it still rests as an equitable assignment. But as Mr. Chairman has been rightly pointed out, there's no time prescribed when the notice of need to be given. So if in future a notice is being given, then the equitable assignment will be turned into a legal assignment.
My point's a slightly different one. You've already given notice because we're here today that there's an arbitration. Could that notice operate as a notice under Section 9?
I understand, but it's not a notice about the assignment of the legal right, but rather it's a notice of arbitration. While it is a notice, is a different form of notice. So it's in our submission that it cannot turn the equitable assignment into a legal assignment. If the tribunal does not have any further question about the first issues?
No.
Thank you, Mr. Chairman. Then I would like to proceed on the second issue. Now, the second issue is really rests on the interpretation of the dispute resolution clause. Mr. Chairman and the member of the tribunal, I need to trouble you to take a read of the dispute resolution clause again. It's in paragraph 2 of the statement of facts. Now, I would also like to deal with certain points raised by my learned friend after reading this course. Any dispute arising or in connection of this charter party can be first resolved by negotiation between the owner and the charterer. If the dispute cannot be resolved 60 days from the commencement of arbitration, any party can submit the dispute for arbitration under HANG term 2021. English law apply. Now, the first key and important word is that any dispute arising or in connection with this charter party, in connection with. Now, there was a damage for the cargo. The whole pay owned by company D, and the insurer, that is the claimant, had properly paid the sum in settling the claim under the liability head of the cargo insurance being covered. Now, the issue is that my learned friend claimed this is as a consequential to the cargo damage. But if you read clearly on this one, definitely it's a claim arising in connection of this charter party. Because when the claim of the vessel failed to operate, it's still within the charter party. It was before the cargo being caused the ship well. So you cannot deny there is no action, but for there's no other reason for the whole pay being damaged, not because of the charter party. It must be because of the charter party. For the shipment of the hot rolled coil, given the king of the vessel had failed to operate and then damaged the hot rolled plate owned by company. So it's in our submission, definitely the claim is fall within the arbitration cost. Now, I would like to go to the second part. Yes.
Mr. Fong, could I just remind you also once again of the time?
Yes, thank you so much, Mr. Chairman. I will speed up my submission. No matter how, Mr. Chairman, if you look into the second part of this dispute resolution clause, if the dispute cannot be resolved within 6 days from the commencement of negotiation, so that is very clear that if there's negotiation, then you need to complete it within 60 days. But if there's no negotiation, you do not offer it, then any party can submit the dispute for arbitration under the HAMAG clause 2021. Now, Mr. Chairman and the members of the tribunal, you will recall clearly Article 8 of the Motor Law or Section 20 of the arbitration order. What is the requirement of a valid arbitration agreement? You only need to be in the written form. So definitely there's a written arbitration agreement here. So definitely it will fall within this arbitration dispute resolution clause for the insurer to submit the claim to the tribunal at this stage. I would like to leave the submission for my co-counsel in addressing issue 2B.
Thank you. As introduced by my learned co-counsel, Mr. Fong, I'm going to deal with the issue 2B in claim skeleton submission paragraph 19 to 24. Claimant's position is that if the meaning of the word can is construed as shall, the dispute resolution clause still did not say that the negotiation is a condition to the commencement of arbitration. The learned author of the International Commercial Arbitration 3rd edition suggested 2 types of provisions, which may be considered as condition precedent. First is the provision expresses itself as a condition or condition precedent to the commencement of arbitration, which is obviously not the case in this dispute resolution process. Second, it also suggests that specific time periods and concrete pre-arbitration steps are more likely to be categorized as condition precedent. The respondent argued that words such as negotiation and 60 days from the commencement of negotiation in our dispute resolution process sufficiently qualify as specific time period and a concrete pre-arbitration steps, as suggested by the author. However, by comparison, I would like to invite the members of the tribunal to look at the provisions at the case CND, the Hong Kong Court of Final Appeal 2023. Clause 14.2 provides parties shall negotiate in good faith. Step 1, either party may give written notice to the other and refer the dispute to CEO of each party. Step 2, CEO shall meet within 10 business days to negotiate. Step 3, if no resolution after 60 business days of the written request for negotiation, then such dispute shall be referred to arbitration. Obviously, the provisions in the CND case has more specific time period and more concrete steps that than those set out in the clause of this reference. So even in that case, the judgment of the final appeal court at paragraph 137, the learned judge, Mr. Justice Gumo, held that as a matter of contractual construction, the precondition contained in clause 14.2 and 14.3 was directly to the obligation to arbitration with respect to the specific claim in question, but not to the agreement to arbitrate. If a provision as sophisticated as that in that CNT case cannot be considered as condition precedent, precluding parties from arbitration, we do not see that the dispute resolution clause in this reference could serve that purpose. Further, the author of International Commercial Arbitration goes on to opine that pre-arbitration procedure requirements were either substantive contractual obligations or procedural rules whose breach entitled a counterparty to damages or procedural relief, but were not a judicial bar precluding a party from validly initiating arbitration. So in the premises, even if the meaning of the word can is construed as shall, the negotiation is not a condition precedent to the commencement of the present reference. That's my learned comment.
Mr. Chairman, the member of the tribunal, I just want to conclude this part. Even if the issuer declarement is wrong, that it constitutes a condition precedent. According to the CND Hong Kong Court of Appeal, at the Court of Appeal level, which upheld by the Hong Kong Court of Final Appeal, and if you turn to page 10, paragraph 25 of my skeleton, it mentioned the dispute as to whether the duty to mediate, in our case, is negotiate, amount to a condition precedent, and if so, whether it has been breached, a matter that should be resolved by the arbitral tribunal as relating to the admissibility of the dispute. Therefore, even if the tribunal held that the negotiation is a condition precedent, the tribunal still have the jurisdiction to decide the matter because it really go to the admissibility of the dispute rather to the jurisdiction of the tribunal. Unless we can assist the tribunal further, this is the submission of the claimant.
Very much, Mr. Bong. Did you wish to make a brief reply, Mr. Chiu?
Thank you. Mr. Chairman, I would, unfortunately, since we do need to go into the CND case a bit more, I just want to raise three quick points. First, on the CND case, I disagree that there was a finding that there was no precondition in the arbitration agreement. Paragraph 61 of the CFI decision clearly says, it is not in dispute that the pre-arbitration condition is a condition precedent to the tribunal dealing with the claim. The question is who finally decides, the tribunal or the court, whether it has been met. And then Mr. Fong, my learned friend's able submissions, he says this tribunal, regardless of what happens, still has the jurisdiction to decide the disputes. Well, we need to distinguish jurisdiction to decide this dispute over jurisdiction. Yes, we agree. Jurisdiction to decide the substantive disputes under the charter party. This is where we differ. And we say that the CND case is very clear on this. Finally, my learned friend, Mr. Fong, said that the only requirement for an arbitration agreement is to be in written form. I don't see how this assists their case. Just because a clause is in writing doesn't make it an arbitration agreement. There still needs to be a clear and unequivocal submission to arbitration. And we say that this has not happened in this case. I understand my learned friend, Mr. Lam.
Yeah, I would also like to reply to my learned friend, Mr. Fong's issue on the point. Well, obviously, he perhaps maybe to a certain extent is due to my fault having made myself clear enough. He has broken down the matter of jurisdiction into several parts and haven't made it clear enough in my submission that what I have we do not disagree that there had been an equitable assignment. We don't disagree. And there's no dispute about that. So frankly, I mean, his reference to all this equitable assignment, well, we accept all these. So it's irrelevant. What we are arguing is that despite the assignment, the dispute resolution clause has not been assigned as such. And in fact, I mean, the very case he referred to, the Rao case, which a Singaporean Court of Appeal case, in page 473, he has referred the tribunal to paragraph 52 and 53 of that particular section, and package JA, the learned package JA, Judith package JA, has made a specific section on the assignability of arbitration agreement in her judgment. In page 473 all the way to the end of the judgment, 475, paragraph 50 all the way to 55. My learned friend has very skillfully drawn your attention to only 52
Thank you, Mr.
and 53 only, without drawing your attention to the rest of the paragraph. In particular, the fifth paragraph, the last paragraph, paragraph 55, which I've drawn to your attention. The package JA has drawn the specific attention to the conceptual difficulty in terms of this assignment. We say that there is such a difficulty.
Mr. Leung, is there anything else?
There's nothing else. Yes.
That's the end of the party submissions. The tribunal will confer very briefly.
I agree with you.
One of my co-arbitrators would like to ask a question.
I'd like to answer the respondent's question about the negotiation part. Because you have, I think both parties agree that can is different to the shall. So can is more permissive and shall is more mandatory. And you have wisely pointed out that there's a big capital italic can, CAN. And you have given the two interpretations on that. And if I take an example in the ordinary oral English, if I say, I can do something, I will do that. But if I say, I can do something, and then follow that, normally I negate that. I can do something, but I choose not to do that. So can you give me some explanation on your interpretation about this big capital can in this clause? Thank you.
Thank you. Thank you, Madam Arbitrator. Our view is that it's quite simple. If there is a dispute, I can go to negotiation and arbitration. Alternatively, I can also go to litigation. But if the word is shall, then I don't have a choice. I have to go to negotiation, then arbitration. That, in our view, is a distinction. I'm not sure if that answers your question.
That's good enough for me.
You have to speak loudly.
Thank you, counsel. The tribunal has deliberated. We thank you both for your very well-prepared, diligent and articulate submissions. You've prepared very helpfully a list of issues, and perhaps I'll give you the benefit of our decision first of all, and perhaps we'll then run through the issues. We found that the respondent side had the more challenging task this particular afternoon, and we have decided to deny the respondent's application, and we therefore find that we do have jurisdiction to proceed with the substance of this arbitration. Dealing with the list of issues. First issue was whether or not subrogation form affected a legal assignment or an equitable assignment. The tribunal was quite engaged with that topic. It's not an easy one. There is a quite nuanced distinction between subrogation and assignment. And then once again, within assignment, of course, we have legal assignments and equitable assignments. In any event, Mr. Leung very graciously agreed that the matter is not in dispute this afternoon, and he has agreed that there has in fact been an equitable assignment. Whether the dispute resolution clause is assignable, we provided some very helpful decisions from the claimant's side, and we have found that the dispute resolution clause in this case both is assignable and was assigned. That then becomes what is known as a derived rights obligation for the claimant as insurer. The third issue was whether the charterer, which the charterer and company D are required to be joined as claimants of the arbitration. We find that the answer to that issue is no, but of course it is common practice. Dealing with the second broad set of issues, which was the dispute resolution clause itself and the question of the relevance of the word can, there were three sub-issues there. First one is, what is the meaning of the word can dispute resolution clause? As my co-arbitrator has indicated very clearly, that language is permissive, and in our view, it is not to be equated with shall. If the meaning of the word, second point, if the meaning of the word is construed as shall, whether the first sentence of the dispute resolution clause is a condition precedent to the commencement of any arbitration, and for reasons just described, we say that it is not to be construed as shall. If the final issue is if the answer to B is in the affirmative, which it is not, so we don't need to dwell on that any further. So that the finding of this tribunal today is that the respondent's application seeking an interim award and or a declaration that we have no jurisdiction is declined. We will hear the parties on costs in due course. And I think we're at the point now where we can turn this over to some discussion with the audience, perhaps.
Yes, that's right. So we have time if any member of the audience has a question for counsel or the arbitrators, you can dive into assignment or into procedure, ask them any question that you have. I should have prepared a question for just this situation if you haven't got anything. I think what we'll do is the council and the arbitrators have spent a huge amount of time in preparing the written submissions, things that you've just seen the statement of facts. They've done written submissions, lists of authorities, as if this was truly a genuine case. So we thank the arbitrators and council for this excellent demonstration. Please join me and with a big thank you.
Could I just add one thing, Bill? Of course, this was dealt with today as a preliminary issue, preliminary objection. In practice, of course, there's nothing to stop you bringing these objections again with the benefit of the knowledge you now have, for example, in a substantive defense. So the fact that you brought the jurisdiction challenge today in an interim preliminary application context would not prevent the respondent from actually recycling these points of defense. Perhaps that's a point you could comment on, Bill.
I will thank you, Mr. Chairman. And if no one else has any more questions, we will now have a 5-minute break before the second hearing takes place. 5 minutes.